Welcome back to the deep dive. Today, we are clearing the desk completely. No stack of disparate articles, no opinion pieces, no Twitter threads, and no conflicting editorials. We have exactly one source document in front of us.
But it is a heavy one, both physically, if you're holding the bound volume, and, metaphorically.
We are looking at the Constitution of India. Now, usually when people talk about the Constitution, they cherry pick. They'll argue about a specific fundamental right, or they'll debate the powers of the prime minister.
Right, or they get into the weeds of a specific amendment.
But today, our mission is fundamentally different. We're going to do something that, honestly, very few people, even law students, actually do in one sitting.
We are going to read it sequentially.
Yes, from start to finish.
Yeah.
From the preamble right through to the schedules.
And there's a reason for that, isn't there?
The logic being that the structure of the book itself tells a story. It's not just a grab bag of laws, is it?
Not at all. It's an architectural blueprint. The drafters laid it out in a specific order for a very specific reason. They define the territory, then the people who live there, then the rights of those people.
And only then.
And only then do they build the government machinery to serve those people. It's a logical cascade.
So here are the ground rules for today's deep dive. We are using the official text updated to May 2024. We are moving strictly from the preamble through the parts, and we will pronounce them as full words, so part 1, part 2, not Roman numerals, and we will finish with the schedules.
No jumping around.
No jumping around.
It's a marathon, not a sprint. The goal is precision and completeness. This is, after all, the supreme law of the land, so let's treat it with that level of respect.
Let's start at the very beginning. The preamble. This is the poetry before the prose, really.
It is the soul of the document.
Oh.
And you have to notice the very first phrase. It doesn't say, we the states, or we the parliament.
It says, we the people of India.
And that sets the power dynamic immediately.
It does.
It establishes popular sovereignty. The power of this constitution flows from the bottom up, from the citizens, not from a monarch or, some external authority giving it to us.
And then it defines what India is. The text declares India to be a sovereign, socialist, secular, democratic republic.
No, if you were looking at the original 1950 text, socialist and secular weren't there.
Oh, that's an important point.
They were added by the 42nd Amendment in 1976. But in the text we have today, they are binding descriptors. Sovereign means no external power controls us. Democratic republic is crucial. Republic means the head of state is elected, not hereditary.
We don't have a king.
We have a president.
Then it lists the objectives, the deliverables of this new state. Justice, liberty, equality, and fraternity.
And look at the order. Justice comes first. Social, economic, and political justice. It suggests that without a foundation of justice, liberty and equality are, well, they're fragile.
Then comes liberty.
Liberty of thought, expression, belief, faith, and worship. Then equality of status and opportunity. And finally, fraternity, assuring the dignity of the individual and the unity and integrity of the nation.
It closes with the adoption date, the 26th day of November, 1949. But we know it didn't fully kick into force until January 26, 1950.
Correct.
Okay, let's turn the page. We are entering the operational text, Part 1, the Union and its territory.
Articles 1 through 4. Before we have a government, we need to know, where is here? What is the actual physical space we're talking about?
Article 1. It drops the most famous definition immediately. India, that is Bharat, shall be a union of states.
That dual nomenclature, India, that is Bharat, was a compromise in the Constituent Assembly. It was about bridging the modern nation-state with the ancient civilizational identity.
But the legal heavy lifting is in that phrase, union of states.
Oh, absolutely. Dr. Ambedkar was very specific about this. He said it is a union, not a federation of independent states.
What's the practical difference there?
Well, in a federation like the USA, the states came together to form a country. They pre-existed the union. In India, the union holds the states together. The union is indestructible.
So no state has the right to secede.
Precisely.
Okay, Article 2 deals with admission of new states like if we acquired new territory. But Article 3, this one is the surprise for many people.
Article 3 deals with the internal map. And this is a huge power. It gives Parliament the power to form a new state by separation of territory from any state, or by uniting two or more states.
They can also increase the area of any state, diminish the area.
Alter the boundaries, and even alter the name of any state.
So Parliament can essentially delete a state or carve it up, and the state legislature can't stop them.
Correct. The president has to refer the bill to the state legislature for their views, but Parliament is not bound by those views at all.
Which is why political scientists often call India an indestructible union of destructible states.
Exactly. The union is paramount.
And Article 4?
It's a housekeeping clause, really. It just says that laws made under Articles 2 and 3 aren't considered constitutional amendments in the difficult sense of Article 368.
So they can be passed with a simple majority.
A simple majority. It makes reorganizing the states a much more flexible process.
Okay, so we have the land. Now we need the people. Part 2, citizenship, Articles 5 through 11.
And you have to read Part 2 with the mental image of 1947 and the partition. It is very, very specific to that moment in time.
Right. So Article 5 defines citizenship at the commencement of the Constitution, January 26, 1950.
Yes. It basically says, if you were born here, or either of your parents was born here, or you've been ordinarily resident for 5 years before the Constitution started, you are a citizen. It's based on domicile and birth. It's a snapshot.
But then Articles 6 and 7 get into the really complex migration issues. Article 6 is about rights of citizenship of certain persons who have migrated to India from Pakistan.
And Article 7 is about rights of citizenship of certain migrants to Pakistan. It's dealing with the tragic reality of millions of people moving across new borders.
And it gets incredibly specific.
It does. It deals with people who left for Pakistan after March 1st, 1947, but then changed their minds and returned to India under a permit for resettlement. These articles are dense with dates like the 19th day of July, 1948, which is when the permit system for return started.
Article 8 looks outward. Rights of persons of Indian origin residing outside India.
This allows for registration as a citizen if you or your parents or grandparents were born in undivided India, even if you are living abroad. It connects the diaspora.
Article 9 is straightforward but incredibly important. Persons voluntarily acquiring citizenship of a foreign state not to be citizens.
And there it is. This establishes that India, by its constitutional design, does not allow dual citizenship. If you take a U.S. passport, you automatically, by operation of this article, lose your Indian citizenship.
Article 10 says, continuance of the rights of citizenship. Basically, once you have it, you keep it, subject to whatever laws Parliament makes.
Which brings us to the most relevant one for us today.
Article 11.
Yes, Article 11 is the handover. The Constitution effectively says, look, we have defined who is a citizen as of 1950, for everyone else, for all future cases, for people born later or naturalizing later, Parliament needs to write a law.
So the Constitution itself doesn't actually tell you how to become a citizen today?
No. It delegated that power entirely to Parliament, and that's why we have the Citizenship Act of 1955 and all its subsequent amendments.
Understood. Now let's unpack the next section. This is the big one. Part 3, Fundamental Rights, Articles 12 through 35.
This is the Magna Carta of India, the heart of the Constitution. These are the rights that are justiciable, meaning if the state violates them, you can go to court and get a remedy.
But first, we have to define who you're protected against. Article 12 defines the state.
And it's a very wide net. It defines the state as the government and parliament of India, the government and legislature of each state, and this is the important part, all local or other authorities.
So your village panchayat is the state.
The electricity board can be the state. A public university can be the state. If they violate your rights, Part 3 applies.
Then Article 13 is the shield. It declares that laws inconsistent with or in derogation of the fundamental rights are void.
This is the ultimate source of the power of judicial review. If Parliament passes a law that violates your freedom of speech, Article 13 is the mechanism the Supreme Court uses to strike that law down.
Okay, now into the specific rights. The first block is the right to equality, Articles 14 to 18.
Article 14 is the bedrock, equality before law. But it's nuanced. It doesn't mean absolute mathematical equality.
You don't tax a billionaire and a beggar the same amount.
Exactly. It allows for reasonable classification, or what the courts call intelligible differentia. But it forbids arbitrary discrimination. The state must act fairly.
Article 15 prohibits discrimination on specific grounds: religion, race, caste, sex, or place of birth.
And crucially, Article 15, Clause 2 extends this to private spaces like shops, public restaurants, hotels, and places of public entertainment.
So you can't have a caste-exclusive hotel.
You cannot. The Constitution forbids it.
Article 16 guarantees equality of opportunity in matters of public employment. But this is also where the reservation policy is anchored, isn't it?
Yes, it is.
Yeah.
Article 16, Clause 4 explicitly allows the state to make provisions for the reservation of appointments for any backward class of citizens, which, in the opinion of the state, is not adequately represented in the services under the state.
So the Constitution balances formal equality with substantive equity right there in the text.
It does. It acknowledges historical disadvantage.
Article 17 is short, brutal, and historic. Abolition of untouchability.
It forbids its practice in any form. It is one of the few absolute rights in the Constitution. There are no reasonable restrictions on this. Untouchability is a crime, full stop.
And Article 18 deals with the abolition of titles.
No more Rai Bahadurs or Maharajas conferred by the state. Military and academic distinctions are allowed. You can be a general or a doctor, but the state cannot create a peerage or an aristocracy.
Moving to the next block. Right to freedom. Articles 19 to 22. Article 19 is the famous one.
It is. Article 19, Clause 1 lists the 6 freedoms citizens enjoy. A, freedom of speech and expression. B, to assemble peaceably and without arms. C, to form associations or unions.
D, to move freely throughout the territory of India. E, to reside and settle in any part of the territory of India.
And G, to practice any profession or to carry on any occupation, trade, or business. And you should note that F was the right to property, which was omitted from this part.
But we cannot read Article 19, Clause 1 without reading Clauses 2 through 6.
Absolutely not. Those are the reasonable restrictions. Your freedom of speech is subject to the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency, or morality.
Or in relation to contempt of court, defamation, or incitement to an offense?
Right. Freedom is not absolute license. The Constitution itself provides the grounds for limiting it.
Article 20 offers protection in respect of conviction for offenses.
It provides 3 crucial safeguards. First, no ex post facto laws. You can't be punished for something that wasn't a crime when you did it.
Second, no double jeopardy.
You can't be prosecuted and punished twice for the same offense. And third, no self-incrimination. You can't be compelled to be a witness against yourself.
Then comes Article 21. If Article 14 is the bedrock, Article 21 feels like the heartbeat of the Constitution.
Protection of life and personal liberty. The text is deceptively simple. No person shall be deprived of his life or personal liberty except according to procedure established by law.
But the courts have blown this wide open, haven't they?
Oh, massively. The Supreme Court has interpreted life not just as animal existence, but as a life with dignity. Over the decades, they have read the right to privacy, the right to health, the right to a clean environment, the right to livelihood, even the right to sleep.
All into Article 21.
All into that one sentence. It is the most expansive repository of rights we have.
And tucked right after it is Article 21A, right to education.
This was added by the 86th Amendment. It compels the state to provide free and compulsory education to all children of the age of 6 to 14 years. It made education a fundamental right.
Article 22 is protection against arrest and detention in certain cases. It says you have to be told why you're being arrested and produced before a magistrate within 24 hours.
That's the standard protection for any arrest. But Article 22 also contains the provisions for preventive detention, and this is a very controversial part of the Constitution.
Why is that?
Because it explicitly authorizes the state to detain people without trial if it's necessary to prevent them from acting in a manner prejudicial to the defense of India, foreign relations, or public order. It sets procedural limits like advisory boards, but it is a constitutionally sanctioned suspension of liberty.
Okay, next block. Right against exploitation. Articles 23 and 24.
Article 23 prohibits traffic in human beings and forced labor. It outlawed the old feudal systems of begar, where landlords forced tenants to work for free.
And Article 24.
It prohibits the employment of children below the age of 14 in factories, mines, or other hazardous employment.
Then we have the right to freedom of religion, Articles 25 to 28.
Article 25 gives all persons, not just citizens, but all persons, freedom of conscience and the right to freely profess, practice, and propagate religion.
But again, it's not absolute.
No, it is subject to public order, morality, and health.
Article 26 is about the group, not the individual. Freedom to manage religious affairs.
Yes, every religious denomination has the right to establish institutions, manage its own affairs in matters of religion, and own and acquire property.
Article 27 is the secularism clause regarding money.
It says no person shall be compelled to pay any taxes specifically for the promotion of a particular religion. The state cannot use taxpayer money to fund a faith.
And Article 28 prohibits religious instruction in certain educational institutions.
Specifically, if an institution is wholly maintained out of state funds, no religious instruction can be provided there.
Cultural and educational rights are next, Articles 29 and 30. These are often called the minority rights.
Article 29 protects the interests of minorities. It says any section of citizens with a distinct language, script, or culture has the right to conserve it.
And Article 30 goes a step further.
It does. Right of minorities to establish and administer educational institutions. This applies to minorities based on either religion or language.
Then we come to Article 31, which is simply marked omitted.
That was the original right to property. It was a fundamental right, but it led to massive litigation when the government tried to enact land reforms and zamindari abolition. So by the 44th Amendment in 1978, it was removed from Part 3.
But it's still in the Constitution, just elsewhere.
Yes, we'll get to that later.
Okay, we have Articles 31A, 31B, and 31C left in this section. These are called saving of certain laws.
These are basically exceptions carved out to protect certain laws. They protect laws related to the acquisition of estates like land ceiling acts from being challenged on the ground that they violate Articles 14 or 19.
And Article 31B is tied to the Ninth Schedule.
That's right. The Ninth Schedule was created as a kind of constitutional vault. Any law placed in it was, for a long time, considered immune from judicial review, even if it violated fundamental rights.
Finally, in Part 3, we reach Article 32, right to constitutional remedies.
Dr. Ambedkar called this the very heart and soul of the Constitution, because a right without a remedy is just a platitude. It's a nice sentence on a piece of paper. Article 32 gives you the right to move the Supreme Court directly for the enforcement of the rights we just discussed.
And it gives the Supreme Court the power to issue these things called writs. Let's name them.
Sure. You have habeas corpus, which literally means produce the body. It's a check against illegal detention. Then mandamus, we command, which orders a public official to do their duty.
There's prohibition.
Stopping a lower court from exceeding its jurisdiction. Quo warranto, by what authority, which challenges someone holding a public office illegally, and certiorari, which is used to quash an order passed by a lower court or tribunal.
So these are the tools the court uses to enforce the rights.
Essential tools.
Article 33 allows Parliament to modify these rights in their application to the armed forces, police, intelligence agencies.
Right. Soldiers don't have the same right to form unions or protest as civilians do. Discipline requires that restriction. Article 34 restricts rights while martial law is in force.
And Article 35 says only Parliament, not state legislatures, can make laws to give effect to certain articles in Part 3.
That's to ensure uniformity across India on these fundamental issues.
Okay, that was the people's rights against the state, a massive section. Now, Part 4. Directive Principles of State Policy, Articles 36 to 51.
The gear shifts here completely. Part 3 was about negative liberty, telling the state what it cannot do, don't discriminate, don't restrict speech arbitrarily. Part 4 is about positive liberty, telling the state what it should do.
But there's a huge disclaimer right at the start. Article 37 says, the provisions contained in this part shall not be enforceable by any court.
Correct. You cannot sue the government for failing to fulfill a directive principle. But the same article also says they are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws.
So they are a moral compass for the government, a to-do list.
A to-do list is a good way to put it.
So what's on the list? Article 38 asks the state to secure a social order for the promotion of welfare of the people.
And Article 39 is very detailed, very socialist in its flavor. It directs the state to ensure citizens have the right to an adequate livelihood, that the ownership and control of material resources are distributed for the common good.
And that the economic system doesn't result in the concentration of wealth.
Right. It also calls for equal pay for equal work for both men and women.
Article 39A ensures equal justice and free legal aid.
This is huge. It ensures that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities.
Article 40 is a clear nod to Gandhi, organization of village panchayats.
It directs the state to take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government.
Then we have a cluster of welfare articles. Article 41, right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement.
Article 42, provision for just and humane conditions of work and maternity relief. Article 43, securing a living wage for workers. Article 43A calls for the participation of workers in the management of industries.
And 43B for the promotion of cooperative societies.
Yes.
Then we get to Article 44. This is the one that sparks debates on news channels constantly. Uniform civil code for the citizens.
The state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. It envisions a common set of laws for marriage, divorce, inheritance, and adoption for all citizens, replacing the diverse personal laws currently based on religion.
But it remains an endeavor.
It remains a directive, not a fundamental right.
Okay. Article 45 focuses on early childhood care and education for children below the age of 6. Article 46 deals with the promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections.
Article 47 is about raising the level of nutrition and the standard of living and improving public health. And this is where the power for prohibition of intoxicating drinks comes from. It's a directive principle.
Interesting. Article 48, organization of agriculture and animal husbandry.
It directs the state to organize agriculture on modern and scientific lines and, this is the key phrase, prohibiting the slaughter of cows and calves and other milch and draft cattle.
Article 48A is about environmental protection.
Protection and improvement of the environment and safeguarding of forests and wildlife.
Article 49, protection of monuments and places of national importance. And Article 50 is vital for the rule of law, separation of judiciary from executive.
Which means the police officer or the district collector shouldn't also be the one acting as the judge. There must be a clear separation of powers.
And finally, Article 51 looks outward. Promotion of international peace and security.
Maintain just and honorable relations between nations, foster respect for international law, and encourage settlement of international disputes by arbitration. It's a very idealistic end to the part.
Then there's a small addition, Part 4A. Just one article here. Article 51A, Fundamental Duties.
This part was not in the original 1950 text. It was added during the emergency in 1976 by the 42nd Amendment. The idea was that if Part 3 is what the state owes you, Part 4A is what you owe the state.
It lists 11 duties in total now.
Yes. To abide by the Constitution and respect its ideals, to cherish the noble ideals of the freedom struggle, to uphold the sovereignty, unity, and integrity of India, to defend the country when called upon.
To promote harmony and the spirit of common brotherhood, to value our composite culture.
There's an interesting one in there, too. To develop the scientific temper, humanism, and the spirit of inquiry and reform.
Which is quite a progressive thought.
It is. Also to protect the environment and safeguard public property. The last one, Clause K, was added in 2002, the duty of a parent or guardian to provide opportunities for education to their child between the ages of 6 and 14 years.
Okay, so we've defined the land, the people, their rights, the state's goals, and the people's duties. Now we build the government. Part 5, the Union. Articles 52 to 151. This is the largest part of the Constitution.
It is. It covers the executive, the legislature, which is Parliament, and the judiciary, which is the Supreme Court, all at the Union level.
Chapter 1, the executive. Article 52 states simply, there shall be a president of India.
And Article 53 vests the executive power of the Union in the president. But, and this is the biggest but in Indian constitutional law, we have to look ahead to Article 74 to understand how this actually works.
Let's jump there for a second then. Article 74, Council of Ministers to aid and advise President.
It says, there shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice.
That word shall is doing a lot of work there.
It's doing all the work. It means the president is a constitutional head. The real executive power lies with the Prime Minister and the Council of Ministers. The president reigns, but the PM governs.
Okay, back to the president. Articles 54 and 55 describe the election. It's not a direct vote by the people.
No, it's an electoral college consisting of the elected members of both houses of parliament and the elected members of the legislative assemblies of the states. This ensures the president represents not just the people, but the federal structure as a whole.
Articles 56 through 60 cover the term of office, which is 5 years, eligibility, qualifications, and the oath. Then Article 61 is a procedure for impeachment of the president.
And it is a very difficult process. It requires a charge of violation of the Constitution and must be passed by a majority of not less than 2/3 of the total membership of the House investigating the charge. It has never happened in India's history.
Moving on. Article 63 says, there shall be a vice president of India.
And Article 64 explains his main job. The vice president shall be ex officio chairman of the Council of States, the Rajya Sabha. That's his day-to-day function, much like the U.S. vice president presiding over the Senate.
Article 72 is the president's power to grant pardons.
This is the sovereign power to pardon, reprieve, respite, or remit punishment, or to suspend, remit, or commute the sentence of any person convicted of any offense, including death sentences.
Article 76 establishes the Attorney General for India.
The top legal officer of the Union government, appointed by the president to give legal advice to the government. He has the right of audience in all courts in the territory of India.
And Article 78 lists the duties of the Prime Minister, which includes furnishing information to the President.
Right. The Prime Minister acts as the constitutional link between the cabinet and the president.
Okay, that's the executive. Chapter 2, Parliament. Article 79 constitutes Parliament.
And it consists of the president and 2 houses. The Council of States, which is the Rajya Sabha, and the House of the People, the Lok Sabha. And notice that the president is part of Parliament even though he doesn't sit in it. A bill doesn't become an act until he signs it.
Article 80 details the composition of the Rajya Sabha, and Article 81, the Lok Sabha.
The Rajya Sabha represents the states. Its members are elected by the state assemblies. The Lok Sabha represents the people directly through general elections.
Article 83 sets the duration. The Rajya Sabha is not subject to dissolution. It's a permanent body with 1/3 of members retiring every 2nd year. The Lok Sabha continues for 5 years, unless it's dissolved sooner.
Right.
There are a lot of articles here on sessions, officers like the Speaker and the Chairman, and conduct of business. But let's look at Article 105, powers, privileges, and immunities of Parliament and its members.
This is critical for a functioning democracy. An MP, a member of Parliament, cannot be held liable in any court for anything said or any vote given by him in Parliament.
So they have complete freedom of speech on the floor of the House.
Yes, to ensure they can debate without fear of prosecution, they have immunity for their legislative speech.
The section on legislative procedure is Articles 107 to 111. Article 108 provides for a joint sitting of both houses.
This is a deadlock-breaking mechanism. If the 2 houses disagree on an ordinary bill, the president can summon a joint sitting.
And since the Lok Sabha has more than double the members of the Rajya Sabha.
The will of the Lok Sabha usually prevails in a joint sitting.
But then Article 110 defines money bills, and these are special.
Very special. This is a category of bills dealing with taxes, borrowing, and the Consolidated Fund of India. Money bills can only be introduced in the Lok Sabha.
And what's the Rajya Sabha's role?
The Rajya Sabha can recommend changes, but the Lok Sabha can accept or reject them. The Rajya Sabha has only 14 days to return a money bill. It cannot kill it. This ensures that the directly elected House has the final say on the nation's purse.
Article 112 is the annual financial statement,
Which you and I would call the budget. It must be laid before Parliament every year.
Okay, Chapter 3 of Part 5 contains just one article, 123. Power of President to promulgate ordinances during recess of Parliament.
This is a legislative power given to the executive branch. If Parliament is not in session and immediate action is required, the President, acting on the advice of the Cabinet, can issue an ordinance.
And it has the same force as an act of Parliament.
It does. However, it must be laid before Parliament when it reassembles. If it's not approved by Parliament within 6 weeks of reassembly, it ceases to operate.
Chapter 4. The Union Judiciary. The Supreme Court.
Article 124. There shall be a Supreme Court of India. It details the constitution of the court and the appointment of judges by the President.
Article 129 declares the Supreme Court to be a court of record.
Which means 2 things. Its records are admitted to have evidentiary value, and more importantly, it has the power to punish for contempt of itself.
The Constitution then lays out the court's jurisdiction. There's original jurisdiction in Article 131 for disputes between the center and states. There's appellate jurisdiction, but Article 136 is the one we hear about most often.
Yes. special leave to appeal. This is an extraordinary power. The Supreme Court can, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed by any court or tribunal in the territory of India.
Except military tribunal.
It's a huge discretionary power that allows the Supreme Court to step in anywhere where it feels a gross injustice has occurred.
Article 141 establishes the law of the land.
The law declared by the Supreme Court shall be binding on all courts within the territory of India. This is the doctrine of precedent, or stare decisis.
And Article 142 gives it a unique power for enforcement of decrees and orders.
This allows the Supreme Court to pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it. It's a sweeping power to cut through legal knots and procedural red tape.
Finally, in Part 5, there's Chapter 5, the Controller and Auditor General of India, Article 148.
The CAG. He's appointed by the president, and his main job is to audit the accounts of the union and of the states.
And Article 151 requires his audit reports to be laid before each House of Parliament.
He is the guardian of the public exchequer. His reports often form the basis of parliamentary scrutiny of government spending.
Okay, we are leaving the center and heading to the states. Part 6, the states. Articles 152 to 237.
Structurally, you'll see this is almost a mirror image of Part 5. What the president is to the union, the governor is to the state. What parliament is to the union, the state legislature is to the state.
Chapter 2, the executive. Article 153. There shall be a governor for each state.
And Article 154 vests the executive power of the state in the governor. But, and this is a key difference from the president, the governor is appointed by the president under Article 155. He's not elected.
Which makes the governor a dual agent of sorts.
It does. He is the constitutional head of the state government, but he is also a representative of the center in the state.
Article 163. Council of Ministers to aid and advise governor with the chief minister at the head.
Just like at the center.
Article 165 creates the Advocate General for the state counterpart to the Attorney General.
Correct. The state government's top lawyer.
Chapter 3, the state legislature. Articles 168 to 212.
Article 168 constitutes the legislatures. For most states, it is unicameral. The governor and one house, the Legislative Assembly, or Vidhan Sabha.
But some states have two houses.
Yes, a handful of larger states have a bicameral legislature, which adds a legislative council, or Vidhan Parishad.
And the powers, privileges, and procedures for passing bills, including money bills, largely mirror the processes we saw for Parliament.
They do, with the state assembly having primacy just like the Lok Sabha.
Chapter 4 is just Article 213, legislative power of the governor.
This is the governor's power to promulgate ordinances when the state legislature is not in session. It's parallel to the president's power under Article 123.
Chapter 5, the high courts in the states. Articles 214 to 231.
Article 214 says, there shall be a high court for each state. But Article 231 allows Parliament to establish a common high court for two or more states, like the one for Punjab and Haryana.
Article 215 makes high courts courts of record, giving them contempt power. But let's look at Article 226.
This is the High Court's writ jurisdiction. It corresponds to the Supreme Court's power under Article 32, but it is actually wider.
Wider? How so?
Article 32 can only be used for the enforcement of fundamental rights. Article 226 allows high courts to issue writs not just for fundamental rights, but also for any other purpose. So you can go to the high court for the enforcement of ordinary legal rights, too.
Chapter 6 covers the subordinate courts. Articles 233 to 237.
This section deals with the appointment of district judges and ensures control over the subordinate judiciary is vested in the High Court, which is a key pillar of judicial independence.
We arrive at Part 7.
Which is repealed. Article 238 is omitted. It used to deal with what were called Part B states, the former princely states, but the States Reorganization Act of 1956 did away with those classifications.
So it's just a historical artifact now.
Exactly.
Part 8. The Union Territories. Articles 239 to 242.
These are territories administered directly by the president, usually acting through an administrator he appoints, like a lieutenant governor.
But there's a very important insertion here. Article 239 AO special provisions with respect to Delhi.
Yes, this was inserted to create the Legislative Assembly for the National Capital Territory of Delhi. However, and this is the crucial part, it explicitly states that the Assembly has the power to make laws on subjects in the state list except for three things: public order, police, and land.
And those three remain with the center.
They remain with the Union government. This structural tension is the source of many of the political and administrative conflicts you see in Delhi.
Next, Part 9, the Panchayats. Articles 243 to 243L.
This part was a landmark addition. It was inserted by the 73rd Amendment in 1992, and it gives constitutional status to local self-government at the village level.
So it's not just a law, it's in the Constitution itself.
Precisely. It defines the Gram Sabha as the foundation, mandates the constitution of panchayats at the village, intermediate and district levels, and, very importantly, ensures regular elections every 5 years.
It also mandates reservation of seats for scheduled castes, scheduled tribes, and women.
Yes. Not less than 1/3 of the seats must be reserved for women.
And then Part 9A, the municipalities. Articles 243P to 243ZG.
Added by the 74th Amendment, also in 1992, it does for urban areas what Part 9 did for rural areas. It provides a constitutional framework for municipal corporations, municipal councils, and nagar panchayats.
So these two parts together create the third tier of governance.
The third tier of federalism, yes.
Part 10, the scheduled and tribal areas. Articles 244 and 244A.
Article 244 is a short but powerful one. It says the administration of scheduled areas and tribal areas shall be governed by the provisions of the 5th and 6th schedules, respectively.
So it carves out special administrative zones.
Yes. It recognizes that certain tribal regions need a different administrative model to protect indigenous culture, customs, and land rights from outside encroachment.
Part 11, relations between the Union and the states. Articles 245 to 263.
This is the gearbox of the federal system. Chapter 1 details the legislative relations.
Article 245 defines the territorial extent of laws. But Article 246 is the core of it all, isn't it? The distribution of legislative power.
It is. It refers us to the 7th schedule of the Constitution, which contains 3 lists. List 1 is the Union list subjects, where only Parliament can make laws like defense, foreign affairs, currency.
List 2 is the state list,
where the state legislature has exclusive power, like police, public health, agriculture. And List 3 is the concurrent list, where both Parliament and the states can make laws. Think education, criminal law, forests.
What happens if they clash on a subject in the concurrent list?
In a direct conflict, Article 254 says the law made by Parliament prevails. The Union law overrides the state law.
And we have a new article here, 246A.
Yes, that was added for the Goods and Services Tax, the GST. It gives simultaneous power to both Parliament and state legislatures to make laws regarding GST. It's a unique model of concurrent power.
Chapter 2 of this part deals with administrative relations. Articles 256 to 263.
Article 256 is key. It states that the executive power of every state shall be so exercised as to ensure compliance with the laws made by Parliament. The center can give binding directions to the states on this.
And what if a state doesn't comply?
Well, that could be grounds for invoking Article 356, President's Rule.
Article 262 deals with adjudication of disputes relating to waters of interstate rivers.
This is very important. It allows Parliament to provide by law that neither the Supreme Court nor any other court shall exercise jurisdiction in respect of such disputes.
Which is why we have specific river water tribunals.
Exactly. To keep these politically sensitive disputes out of the regular court system.
Okay, a big one next. Part 12. Finance, property, contracts, and suits. Articles 264 to 300A.
Chapter 1 is finance, and it starts with a golden rule in Article 265. No tax shall be levied or collected except by authority of law.
The government can't just demand money from you.
They need a statute, a law passed by the legislature to do so. It's a cornerstone of the rule of law.
Article 266 establishes the Consolidated Fund of India, where all government revenues go and from which all expenditure is made. And Article 267 establishes the Contingency Fund for unforeseen expenditure.
Right, a sort of emergency kitty for the government.
Then Articles 268 through 279, a deal with the complex distribution of revenues between the Union and the states.
The union collects the big, efficient taxes like income tax and corporation tax, but the states have heavy spending responsibilities like health and policing. So the Constitution provides for a mechanism to share the proceeds.
And that mechanism is Article 280, the Finance Commission.
Yes. The president constitutes a finance commission every 5 years. It's an independent body that recommends how the net proceeds of taxes are to be divided vertically between the union and the states and horizontally among the states themselves.
We also have Article 279A, which constitutes the Goods and Services Tax Council.
This is a modern example of cooperative federalism, a joint forum of the center and all the states to make recommendations on GST rates and implementation.
Chapter 4 of Part 12 is interesting. Just one article, 300A.
Persons not to be deprived of property save by authority of law. This is where the right to property landed after it was evicted from Part 3.
So it's still a right, just not a fundamental one.
It is a constitutional right. The difference is, if the state takes your property for a public purpose and passes a law for it, you can't challenge that law on the grounds that it violates the basic structure in the same way you could a fundamental right. But you are still entitled to compensation under that law.
Part 13. Trade, Commerce, and Intercourse within the Territory of India. Articles 301 to 307.
Article 301 is the key declaration. Trade, commerce, and intercourse throughout the territory of India shall be free. The goal is to create a single national economic market without internal border tariffs between states.
But the subsequent articles allow Parliament and states to impose reasonable restrictions.
Yes, in the public interest.
Part 14. Services under the Union and the states. This regulates the bureaucracy.
Yes, Articles 308 to 323. Chapter 1 covers the services, and Article 311 is the shield for civil servants.
What does it do?
It provides procedural safeguards against arbitrary dismissal. It says no person in the civil service shall be dismissed or removed by an authority subordinate to the one that appointed him, and not without a proper inquiry where he is given a chance to be heard. It provides security of tenure.
Article 312 provides for the creation of all India services.
Like the IAS, the Indian Administrative Service, and the IPS, the Indian Police Service. These are unique because they are recruited by the center, by the union government, but they are assigned to and serve in the various state cadres.
Chapter 2 of this part deals with the Public Service Commissions.
Article 315 establishes the Union Public Service Commission, the UPSC, and State Public Service Commissions. These are independent constitutional bodies tasked with conducting examinations and making appointments to ensure a merit-based, non-political civil service.
Part 14A Tribunals. Articles 323A and 323B.
This was added by the 42nd Amendment. It allows Parliament to set up administrative tribunals to adjudicate service-related disputes of government employees and other tribunals for matters like tax, foreign exchange, and so on, to reduce the burden on the regular courts.
Part 15. Elections. Article 324 to 329.
And Article 324 is the powerhouse here. The superintendent's direction and control of elections to be vested in an election commission.
And this Election Commission of India, the ECI, is an independent constitutional authority.
Yes, it is kept separate from the government of the day to ensure free and fair elections.
Article 325 says no person shall be ineligible for inclusion in the electoral roll on grounds of religion, race, caste, or sex.
A universal role.
And Article 326 is revolutionary. Elections to the House of the People and to the legislative assemblies of states to be on the basis of adult suffrage.
Think about that. In 1950, in a largely illiterate and desperately poor country, the Constitution gave every adult citizen, originally 21 and older, now 18, the right to vote. It was a massive, unprecedented leap of faith in democracy.
Part 16. Special provisions relating to certain classes. Articles 330 to 342A.
This is the constitutional machinery for affirmative action. Article 330 reserves seats for scheduled castes and scheduled tribes in the House of the People, the Lok Sabha.
And Article 332 does the same for the state legislative assemblies.
That's right. These reservations are based on the proportion of their population.
We also have the commissions.
Yes. Article 338 establishes the National Commission for Scheduled Castes, Article 338A, the National Commission for Scheduled Tribes, and a more recent addition, Article 338B, the National Commission for Backward Classes.
And these are powerful bodies.
They are constitutional bodies with the powers of a civil court to investigate complaints and monitor the implementation of safeguards for these communities.
Part 17. Official language. Articles 343 to 351.
Chapter 1 deals with the language of the Union. Article 343 says the official language of the Union shall be Hindi in Devanagari script.
However,
There's a big however. It also stated that for a period of 15 years from the commencement of the Constitution, the English language would continue to be used for all official purposes.
and that period was extended.
Yes. Article 343, Clause 3, allowed Parliament to provide for the continued use of English beyond that period, which it did via the Official Languages Act. This was due to strong resistance from non-Hindi-speaking states, particularly in the South.
Chapter 3 covers the language of the Supreme Court and High Courts.
And Article 348 is categorical. Notwithstanding anything else, the language of all proceedings in the Supreme Court and in every High Court, and the authoritative text of all bills and acts shall be in the English language.
So English remains the language of the higher judiciary in national law.
Yes, it does.
Part 18. Emergency provisions. This is where the Constitution shows its teeth. Articles 352 to 360.
And there are three distinct types of emergencies envisaged here.
The first is Article 352, Proclamation of Emergency.
This is the national emergency. It can be declared if the president is satisfied that the security of India is threatened by war, external aggression, or armed rebellion.
And its effects are drastic.
They are. The federal structure essentially becomes unitary parliament can make laws on subjects in the state list, and many fundamental rights under Article 19 are automatically suspended, while the enforcement of others can be suspended by presidential order, except for Articles 20 and 21.
The right to life and protection from conviction.
Those can never be suspended.
The second emergency is Article 356.
This is provisions in case of failure of constitutional machinery in states. It is popularly and often controversially known as President's Rule.
So if a state government breaks down,
If the president, on receipt of a report from the governor or otherwise, is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, he can take over the administration of the state. The state assembly is either suspended or dissolved.
and the third type is Article 360.
Financial emergency. If the president is satisfied that a situation has arisen whereby the financial stability or credit of India is threatened, under this, salaries and allowances of government employees, including judges, can be reduced.
And this has never been invoked.
Never in India's history.
Part 19. Miscellaneous. Articles 361 to 367.
Article 361 provides legal protection to the president and governors. They are not answerable to any court for the exercise of their official duties, and no criminal proceedings can be instituted or continued against them during their term of office.
Article 366 is a big definitions clause.
Yes, it defines dozens of terms used in the Constitution, like agricultural income, goods and services tax, scheduled castes, scheduled tribes, etc. It's the official dictionary for the document.
Yeah, Part 20, Amendment of the Constitution. Just one article, 368.
This is the mechanism for change. It gives Parliament the power to amend the Constitution and lays down the procedure for it.
And how does that work?
For most parts of the Constitution, an amendment requires a special majority. That means it must be passed in each house by a majority of the total membership of that house, and by a majority of not less than 2/3 of the members of that house present and voting.
But for certain sensitive federal provisions, there is an extra hurdle.
There is. If the amendment seeks to change provisions related to the election of the president, the powers of the Supreme Court or High Courts, the distribution of legislative powers between the Union and states, or Article 368 itself.
When you need something more.
Yes. The amendment must also be ratified by the legislatures of not less than 1/2 of the states.
Part 21, Temporary, Transitional, and Special Provisions. Articles 369 to 392.
And this is where the famous Article 370 was located. The text in front of me says, temporary provisions with respect to the state of Jammu and Kashmir.
The text also notes a reference to Appendix 3 here.
Yes, and that appendix clarifies that in August 2019, the president used the powers granted within Article 370 itself to issue a declaration that effectively made all clauses of the article inoperative. The result is that the entire Constitution now applies to Jammu and Kashmir without the previous exceptions.
Then we have a long list of special provisions for other states. Article 371 for Maharashtra and Gujarat, 371A for Nagaland, B for Assam, and so on through 371J for the Hyderabad-Karnataka region.
And these are designed to address specific regional needs. They might protect customary laws and land ownership rights of tribal communities, or provide for special development boards to ensure regional equity within a state.
Finally, we reach the end. Part 22. Short title, commencement, authoritative text in Hindi and repeals. Articles 393 to 395.
Article 393 says this constitution may be called the Constitution of India. Article 394 sets the date of commencement, January 26, 1950.
And the last one, Article 395.
Repeals. It formally repealed the foundational statutes of British rule. The Indian Independence Act, 1947, and the Government of India Act, 1935. This was the final legal act of severing the link with the British Empire.
We have finished the articles, from 1 to 395. But we are not quite done. We have the schedules.
These are the 12 addendums at the back of the book, the lists and tables that were too bulky to fit into the main articles.
Let's run through them. First schedule.
Names the states and union territories and describes their territorial extent.
Second schedule.
Lays out the provisions as to emoluments, allowances, and privileges of the president, governors, speaker, judges, and the CAG.
Third schedule.
This contains the forms of oaths or affirmations, the specific scripts that are read out during swearing-in ceremonies for various constitutional posts.
Fourth schedule.
This details the allocation of seats in the Council of States, the Rajya Sabha, to each state and union territory.
Fifth schedule.
Contains provisions for the administration and control of scheduled areas and scheduled tribes in states other than the Northeast. It mandates the establishment of tribes advisory councils.
Sixth schedule.
And this has provisions for the administration of tribal areas in the specific states of Assam, Meghalaya, Tripura, and Mizoram. It's a more powerful framework that creates autonomous district councils with their own legislative and judicial powers.
Seventh schedule.
This is the one we referred to earlier. It contains the 3 lists that distribute legislative power. List 1, the union list. List 2, the state list. And list 3, the concurrent list.
Eighth schedule.
Languages. It lists the 22 languages officially recognized by the Constitution.
Ninth schedule.
Validation of certain acts and regulations. This is the schedule that was created to protect land reform laws from judicial challenge.
10th schedule.
This was added in 1985.
Sorry.
It contains the provisions for disqualification of members on the ground of defection. It's the anti-defection law.
11th schedule.
Added in 1992 along with Part 9. It specifies the powers, authority, and responsibilities of panchayats, listing 29 matters they can legislate on.
12th schedule.
Also added in 1992, it specifies the powers, authority, and responsibilities of municipalities, listing 18 matters.
And that is the sequential guide to the Constitution of India.
From the preamble all the way to the 12th schedule.
It is absolutely massive. But when you walk through it in order like this, you really see the logic. You see the nation being built step by step, idea by idea.
You do. It balances a strong union with powerful federal states. It balances individual liberty with the need for social control. It balances the rigidity of written law with the flexibility of amendment. It is, in my view, one of the most ambitious and complex legal documents ever written.
And for a final thought, perhaps that balance between the rigid structure that holds everything together and the flexibility to amend it via Article 368 is what keeps it a living document.
Exactly. It's not a static museum piece. It breathes. It argues with itself. And it endures.
Thank you for guiding us through this marathon. It was incredibly illuminating.
It was a pleasure to revisit the text in such a structured way.
And to our listeners, thank you for sticking with us on this deep dive. Our advice, go read the text yourself. It is, after all, your contract with the state. Until next time.